to explain why he deliberately disobeyed the orders of summons by the court, which led to his conviction and sentence. The Law Society of Kenya, led by the President Emeritus Nelson Havi, has urged me to deny Mr. Masengeli the opportunity. He has revealed that he has revealed to this court from the bar that the missing persons have now been released, and all I should do is to allow Mr. Masengeli to confirm that he has complied with the orders of habeas corpus so that these proceedings can come to an end. Additionally, he has argued that Mr. Masengeli has filed 2 applications before the Court of Appeal where he has appealed against a conviction and sentence, and one where he seeks an order of stay of these proceedings. Mr. Dan Manzo has argued or submitted that the court is now functus officio, since the jurisdiction of this court now rests with the Court of Appeal, has now been vested with the Court of Appeal following the filing of the 2 appeals. This position has been strongly opposed by counsels for the first respondent, Mr. Miller and Mr. Ogola, who have argued that the court gave a coercive order which end compliance requirement. Further, the proceedings before the Court of Appeal are intended to deal with the conviction aspect and not the sentence. In making a decision on the issue before me, I must make a reference to the sentence of the order I made on the 13th of September 2024. In sentencing for contempt, there are normally 2 ways of punishing a contemner. Okay, 2 major ways. The court can choose to adopt a purely punitive approach, or can choose to use a coercive approach in which it includes what is known as the purging conditions. The coercive approach gives the contemner the opportunity to save himself from punishment, the equivalent of purgatory in religious circles, so that if the contemner complies and fulfills the obligation required of him by the court can weigh and consider whether he has cleansed himself of the original sin. In my ruling on the 13th of September 2024, I had this in mind when I included condition number 4, which stated as follows: the court nevertheless considers it desirable to impose a coercive order as opposed to the punitive order. In this regard, Mr. Gilbert Masengeli can avoid serving the sentence if he complies with the direction to obey the court summons. I thus suspend the sentence for 7 days only. The acting Inspector General can redeem himself by availing himself before the court in person to answer to the issues he has been avoiding within 7 days. In default, the sentence shall automatically become effective. Having stated as much, and the contemner having availed himself before the court before the lapse of the 7 days, I would be going against my own orders if I deny him audience as urged by the LSK. This is a court of justice and must act fairly at all times towards those that appear before it. Mr. Masengeli is entitled to be heard by virtue of this court order. The Court of Appeal has not taken away the jurisdiction of this court, for it has not issued any order being the barring this court from hearing Mr. Masengeli. This court is not functus official either, as the sentence was not purely punitive but coercive, laced with purge conditions that the court reserved to consider before the sentence becomes effective. I will thus allow Mr. Masengeli to take to the stand and redeem himself.
My Lord, can you give directions on each side?
He must be on the dock.
My Lord.
Yes.
You are the on procedural matter.
Yes.
Stemming from the natural right to challenge that yes.
Yes.
The petitioners reserved the right to cross-examine. My Lord, with your kind permission, this is a matter between the court and the contemnor, and it is straight law that the petitioners have no right to cross-examine.
Okay, let the order.
Sorry, that cannot be the premise. Because if it's just a minute, I have a right to that motion. If he insists that we ought not to be here,
Yes.
we may as well walk out and
Okay,
go.
okay. Let me do this, Mr. Harvey. Kindly listen. Let him explain. Immediately he has done that, I will seek. I'll seek what submissions from you on whatever issue you want. Then I will do on it. But for now, let's just follow the order. Let's hear him.
My colleague has actually made a
Yes.
request in advance.
Yes.
It is taking oath from the Bible. We will reserve our right to cross-examination.
You will reserve the right to cross-examine, but let's first hear him. Then we can see whether it is necessary for you to cross-examine. Because you see, why do you make the decision to cross-examine before you have even heard what he says?
Precisely, my
No, a prudent lawyer
No,
must
just wait. Just wait.
convey to the court what he intends to do.
Yeah, just wait until he does it. Then we will consider.
My Lord, may I seek your leave?
Yes.
May I seek your leave to leave the court?
Very well. Thank
Mr. Mutinda and Mr. Bita
It's okay.
will appear. Thank you so much.
Okay, Annette, swear the witness. Swear him.
So you repeat after me. I swear by the name of the Almighty God.
I swear by the name of Almighty God.
I swear by the name of the Almighty God
I swear by the name of Almighty God
that the evidence I shall give
that the evidence I shall give
touching the matter in
touching the matter in question
question shall be the truth,
shall be the truth,
the whole truth,
the whole truth,
and nothing but the truth.
and nothing but the truth.
So help me God.
So help me God.
You can start with your full name.
Kindly tell the court your full name, please.
My name, Gilbert Masengeli, Deputy Inspector General of Administration Police.
Can you tell the court the specific roles or role that you have been serving within the Inspectorate of Police?
My Lord, some of my duties and responsibilities is border security, ensuring that our borders are safe from incursion within and without for the safety of the Kenyan, my Lord.
Now, you have sworn an affidavit dated the 20th day of September 2024, which is here. Is that correct?
Yes, my Lord.
Affidavit dated?
20th of September 2024.
You've not been served with this affidavit?
It's been forwarded to Rebecca's phone 5 minutes ago. So, don't expect it to read an affidavit from the phone.
Would it assist if I give you time to go through the affidavit? Because I can adjourn briefly so that you go through it, if that is what you want. Because basically what he's trying to say is he's going to rely on some of the information in the affidavit. Is it possible for me to allow you to go through that affidavit? I have a copy. I have a copy here, but I would, if you don't mind, I could ask my court assistant to have it photocopied at the court.
Although there is a return of service.
No, let's not get to that. We just want to do things in the right way. Yeah. Yeah, I just wanted them to get a copy. Mr. Nelson Avi, I want us to agree. Can I adjourn for 20 minutes so that you can, maybe 20 or 30 minutes if you wish?
I think 20, even 15 would be good.
Very well. So in So let's, from good order, let's adjourn for 20 minutes. We allow the petitioners to peruse the affidavit, and then we can proceed after that. I think it's important that we proceed when we are on the same wavelength. Yeah. Kindly let's adjourn and.